After hearing both the parties at length on various arguments, including but not limited to the judgment of this honorable court. Of course, other things must have been said, but the point you thought fit to mention was only Nabab Area here. That's your prime point. That's your showpiece. Including but not limited to the judgment of this honorable court in Nabab, the division bench of this court as an interim measure extended the time to file the reply to the summons notice of disqualification solely in compliance with the basic principles. This is the stay also. This is the stay. You moment, your lordship knows, direct or indirect by any means, your lordship disables the speaker from passing an order X or Y on disqualification. That is a temporary stay. And nobody will question the Supreme Court. Nobody will go ahead after your lordship says, I extend the stay. The court says, no, there is no formal stay. Therefore, I will go and decide the disqualification. Without time. That cannot happen. Your lordship knows that. So that, is my first point. On reference, it is of direct relevance. The Honorable Chief Justice put that question squarely, that please do only tell us about reference. Absent an agreement with all forms, all facets of Nabam, your lordship would and must with great respect refer it. Distinguishing it, your lordship has heard enough arguments, is not the correct course of action, is not going to really, it might generate more future litigation than solve any problem. Your lordship would either, in a binary sense, agree or refer. And agreement, according to our side, is not possible for the variety of reasons given respectfully to your lordships. Now, the second aspect is, your lordship has been taken a lot into this 7-day, 14-day notice of intention, actual removal. That's a valid point. But it should not be thought that the reference, as and when it is decided, if made by your lordships, is on a singular point of working out these days or the stage. The reference would raise significant issues, and one of the...
Have you formulated the issues with Dr. Singhvi?
Well, it's not in this writing form. I'll give a one page.
Try that.
Give a one page.
You can try it right now, because
yes.
Now.
There are many issues, but the core issue would be... No, I'm just saying, in the light of the argument that 7 days or 14 days can be harmonized. Your lordships can hold on notice of intention to remove or the sitting. No, your lordship would have to decide the larger core issue.
Correct.
Which is 7-judge bench deserves to decide.
It's not just
whether your lordships can directly or indirectly conflate chapter 3 and 10 schedule. Or to be more precise, 179 to 182, etc. and the 10 schedule. What is the chapter? Chapter 3. We are not saying this is the only issue. I don't misunderstand me. I am on the Nabab area point. There are many other issues. Tomorrow it will be said that I am giving up all other issues. No. On Nabab area, the issue is not about days and time and sitting. Now, why it has already been said, so I will not repeat this, but just note in bullets why this conflation is very dangerous, or at least has to be decided. The heart of the error of Nabab is a conflation, a mix-up of two distinct. One, I'm giving a in bullets the reason. One, not only Kyoto, but starting from Kyoto, case after case after case, constitution bench after constitution bench said, 10th schedule is a code in itself. This has been forgotten. CODE is repeated everywhere. Code in itself. Self-contained autonomous code. This word is very important, Malaz. So, Malaz, it's an impregnable, self-contained code. I made the point indirectly about notwithstand and subject to. But it's a code. That's Kyoto starts with Kyoto, it says it's a self-contained code. So there can't be a conflation like this. 2, there is a continuity envisaged in 10th schedule, even if a lot of adventurous action is happening in the rest of the constitution. With the speaker. The para 6.1 which Mr. Sibbal read, the proviso, illustrates 2 things. There cannot be a hiatus, stoppage or lack of continuity in 10th schedule. Malas, they have gone that far to anticipate that he is the speaker. This speaker, Malas, will have a disqualification against himself because he has done some untoward act. And your lordship has used another phrase, persona designata. Normally, Malas, in 10th schedule, the persona designata is the speaker, and a persona designata means no one else by exclusion. That's the meaning of a persona designata. They anticipated and said, yes, it is a persona designata. But what in the strange case where I myself am facing a disqualification? No stoppage, no lack of continuity, no hiatus. Anybody else will be elected and will become the speaker, so-called, for the 10th schedule purposes. That's proviso to 6, para 6 bracket 1 of the 10th schedule. The third reason you can't conflate, because of the whole idea is continuity. The third reason is that, well, it was said, Mr. Sibyl did say, but I want to elaborate on that there is no 10th schedule of the old kind, now only defences. Now, your Lordship may not have looked this time, but earlier Lordship saw. 4, 5 and 6 are very interesting clauses. The defences are very limited now. 4, 5 and 6 are the only defences. As my Lord knows, there was 3, which is conspicuous by its absence by the 91st Constitution Amendment of 1104 that deleted clause 3, the split. Now just see the nature of the defence, fellows. 1, merger. I'll not read it. That's fellows clause 4. Now merger, fortunately for all of us, is not even alleged or pleaded or claimed by them. Forget your Lordship finding merger. It is not their case. Second exemption is, well, it's a kind of a sympathy condonation. If he rejoins, there are cases where the person will rejoin. So you have a provision by which he can be let off. That is fine. Now, that brings me to the 4th bullet under this. What is the purpose of this? Well, as your Lordship will read Mr. Ashok Sen's speech when 85, this was brought in for the first time, 10th schedule. Well, he said all this constitutional sin, stigma, purity, all that is there in that speech.
Ayaram.
That had happened, Malus. There were 2 actual names of actual MLAs in Haryana in 1967. These are the names of actual 2 MLAs. That's how this phrase has occurred. Now, he cites all that. Then your Lordship has these amendments to delete. The object is that defection is a per se doctrine. Defection becomes a per se doctrine because you give highest weight to maintain purity. Well, as your Lordship is, with great respect, thinking of a very, very unique, extreme case. It will be academic, it won't happen in politics. Of everybody leaving except the Chief Minister and the Speaker. Theoretically, it can happen. But well before that, everybody will leave, including the Speaker, or he will be removed, as Mr. Sibyl said. So it doesn't really arise. It will not, should not come into your Lordship's analysis of how to deal with this Nabam issue. The object is that as long as even the majority or large number or small number, minority, split, anything goes, we bring it straight, because we have found from 85 till these amendments came that the split and so many other defences were being used. So, therefore, it's a per se doctrine. In a per se doctrine is the 5th bullet. The Speaker has to get only 2 things, Kindly note that. What does he have to get? Why? He has to get, any evidence of voluntarily giving up or voting or abstaining. They're the only 2 categories. Now, second is easy. There's a whip to be shown. You absented yourself or did not vote. The first one is, your Lordship is interpreted in 10 judgments by conduct, by going to the governor, by being photographed on a podium with giving speeches with the opposition. All the judgments are there. So the Speaker must act if the 10th schedule is a constitutional sin prevention. Your Lordship cannot allow the other side to ask him, you can act, but you may be biased. May be biased. So that's my second point. My third point is, this alacrity point. And I'm not on the general point which your Lordship asked, but on the particular point which both Chief Justice and Justice Narasimha asked, on the notice period. Your Lordship said they may have some relevance to what is the notice period which the Speaker gives. Now there, just for the record, your Lordship asked that question. Just note down this and then I'll give your Lordship. There are 3 judgments which are very important. Lordship, note down, then I'll give your Lordship. One is Ravi Nayak. It's a division bench from Goa. 1994 supplementary to SCC 641. PDF 191 of the CC1 case law compilation.
Supplementary 2 SCC page.
94 supplementary to SCC 641. It starts as your lordship's compilation of cases as PDF 191. And the relevant part is para 24 at PDF 204. Don't go to it, just give me a minute. Don't go to it now. The second judgment is Yedurappa, which is not in any compilation that I know of. Just note the citation, need not go to it. 2011, 7 SCC, page 1. Both of these, Ravi Nayak and Yedurappa, are division benches. Both are division benches. The judgment I'll take your lordships to, which covers these two, is Srimant Patil, which is 2020, volume 2 SCC 595, PDF starting page 1249, and relevant paras are 109 to 112. The ratio is in 112, and the PDF page is 1292. Now note, Wallace, two things before I read that last judgment only. Goa, which is Ravi Nayak, has a rule of 7 days. Goa has 7 days. Both the Karnataka judgments, Yedurappa and Srimant Patil, also have 7 days. So Karnataka rule is the same as Goa. The actual notice in Ravi Nayak was 2 days. So less than the rule prescribed. This has great relevance to both the Honorable Chief Justice's query and Justice Narasimha's recollection on that, which is important. In Yedurappa, 3 days was given, and Srimant Patil, 3 days was given. Again, the rule said 7 days. The nub of the matter is that in Srimant Patil, the 3-judge bench said that what is important is not just the text of the 7-day rule in the legislative rules.